Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. The Delhi High Court today refused to entertain another public interest litigation seeking removal of Arvind Kejriwal from the post of Chief Minister of Delhi as he has been arrested by the Enforcement Directorate in the liquor policy case. The PIL was filed by the National President of Hindu Sena. It was argued that if Kejriwal is guilty of constitutional breach of trust, then he has no business to continue on the post of Chief Minister, and that someone else from the Aam Aadmi Party can be appointed on the post. That after his arrest, there was an absolute lack of government in the national capital and a constitutional deadlock had been created. But the court refused to interfere. It stated that personal interests sometimes need to yield to national interests, but Kejriwal's decision was his own. The bench led by Acting Chief Justice Manmohan emphasized that they are a court of law and asked if there was any past incident where the court had imposed President's rule or Governor's rule. The Supreme Court bench comprising Justices Suryakant and K.V. Vishwanathan today continued hearing the matter related to rift within the Nationalist Congress Party. It was dealing with two applications. One moved by the Sharad Pawar group, which alleged non-compliance of the Supreme Court's order by the Ajit Pawar group regarding publication of disclaimers in every pamphlet, advertisement, audio or video clips issued. While the other application came from Ajit Pawar's faction seeking to modify a requirement in the Supreme Court's order. Both the applications were disposed of by the Supreme Court today. Senior advocate Dr. Abhishek Manu Singhvi, representing Sharad Pawar, today presented various advertisements and posters from the Ajit Pawar group across print, electronic and social media. Singhvi alleged that none of these materials included a disclaimer indicating that the use of the clock symbol was under legal scrutiny. Senior advocate Mukul Rohtagi, appearing for Ajit Pawar, alleged that the Sharad Pawar group was using the clock symbol and was not using the name allowed by the court, that is NCP Sharad Pawar. While clarifying that it was not going to modify its previous order, the court directed both Ajit Pawar and Sharad Pawar groups to strictly abide by the court's previous interim order. After the court pointed out that the public notices issued by the Ajit Pawar group regarding the sub judice nature of the clock symbol were in small corners of the newspapers, senior advocate Mukul Rohtagi on their behalf agreed to issue public notices in more prominent spaces in the newspapers. In an important update, the Supreme Court today reversed a judgment of the Bombay High Court which had set aside scheduled caste certificate of Amravati MP Navneet Kaur Rana, who won 2019 Lok Sabha elections from a constituency reserved for scheduled castes. She had challenged the Bombay High Court judgment of 2021 where it was observed that she fraudulently obtained caste certificate for the caste Mochi even though records indicated that she belonged to the caste Sikh Chamar. The High Court stated that the terms Chamar and Sikh Chamar were not interchangeable. It had also clarified that Sikh Chamar did not equate to Mochi as listed in the Constitution. The court had also found fault with the Scrutiny Committee for changing Entry 11 of the Constitution's Schedule 2. They added Sikh Chamar to Entry 11, which the court said was not allowed. This decision of the High Court led to invalidation of her election. Aggrieved, she approached the Supreme Court contending that her forefathers belonged to the Sikh Chamar caste, wherein Sikh is a religious prefix and does not pertain to the caste. It was her case that she belongs to the caste Chamar. While pronouncing the verdict today, the bench of Justices J.K. Maheshwari and Sanjay Karol said that the Scrutiny Committee had validated Rana's caste certificate after due application of mind and on considering relevant documents. Further, all parties were heard and principles of natural justice complied with. As such, High Court's interference with the committee's findings was not merited. Also, let me tell you here, back in 2019, Rana was elected as an independent candidate from Amravati. Now she has been given ticket by the Bharatiya Janata Party to contest from the Amravati in 2024 Lok Sabha elections. The Supreme Court today held a full court reference to pay homage to the late senior advocate Mr. Fali S. Nariman, who passed away on 21st February this year. Members of the legal community, including lawyers, judges, and Mr. Nariman's family, came together to reflect on the legacy and teachings of the jurist, providing inspiration for many to follow. In his reference speech, Attorney General R. Venkata recalled how Mr. Nariman continued to dedicate his life to issues of socio-political concerns till the very end and celebrated constitutional milestones achieved by juniors in the fraternity. The Chief Justice, Dr. D.Y. Chandrachud, delivered a heartfelt homage to Mr. Nariman today. He highlighted the unparalleled virtues Nariman embodied throughout his illustrious career. The CJI also mentioned how even in the last phase of his life, he actively contributed towards the endeavors of the Supreme Court and Supreme Court lawyers, be it by writing an essay on the 75th anniversary of the Supreme Court or by guiding senior advocates in the constitution matters. Mr. Nariman passed away at 95 years old. A distinguished constitutional lawyer, he has argued several landmark cases, including the famous N-Jack verdict. His autobiography, Before Memory Fades, is a widely read book, especially among law students and young lawyers, acting as a source of inspiration for them. An intervention application has been filed by Advocate Mahmood Pracha in the matter pending before the Supreme Court regarding electronic voting machines and VVPAT verification. He has suggested that voting in the upcoming Lok Sabha elections should be conducted through ballot papers. The application states that Pracha has been requesting the Election Commission of India to conduct the elections through the constitutionally and statutorily mandated mechanism, that is through ballot papers, to ensure that the process is fair, transparent and free from any illegal manipulation. However, there has been no response. On the strength of the Election Commission of India handbook titled EVM Brochure for Candidates and Political Parties, he claims that there is no inherent scrutiny feature in the mechanism of EVMs. The application further asserts that a system where the voter may take the VVPAT slip and deposit it in a ballot box himself as an alternative of greater transparency than the current system, where it is not possible for the voter to verify his vote at any stage. Let me tell you, Pracha is himself contesting the Lok Sabha elections as an independent candidate from a constituency in Uttar Pradesh. Coming to an update from the Calcutta High Court, which has reserved its verdict in various pleas seeking an investigation into the alleged instances of violence against women and land grabbing which had occurred in Sandeshkhali, West Bengal, under the watch of former Pradhan Shah Jahan Sheikh and his workers. Earlier, the court had directed the investigation into the attack on ED officials, allegedly at the behest of Sheikh's officials, to be transferred to the CBI as well as custody of Shah Jahan Sheikh. Stay tuned with us to know the verdict in the matter. And lastly, the Delhi High Court has dismissed a public interest litigation which sought a direction on the Delhi government to ban cross-gender massages and spas or massage centers in the national capital. The PIL had contended that cross-gender massages were being carried out in various spas and massage centers in the national capital, which was a violation of guidelines of operation of spas and massage centers in Delhi, issued by the Delhi government in the year 2021. It was stated that such massages were being provided in locked rooms in violation of the guidelines, which also led to operation and proliferation of illegal prostitution. The bench of Acting Chief Justice Manmohan and Justice Manmeet Singh Arora noted that the challenge to the validity of these guidelines was already pending consideration before a single judge. Therefore, the court refused to entertain the PIL. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.